does have some ramifications for cases on appeal, but I think it's more psychological for the patient. So what happens if you've got this great order, the doctor tells you you need to go to the doctor, you need to go to the therapist, you have to take these medications? What happens if the patient stops doing this? Then the custodian is entitled to just take this order and it's in their hand to take it to the police, and the police will take the patient directly back to the mental health facility. So you got something hanging over the patient's head, which is really what you need. You need the structure. You need something in writing to show the patient, this is what we expect you to do. And you need something to show to the patient, if you don't do it, we're going right back to the hospital. So it can be a very empowering order for some patients. Also, the order can be for a much longer time. As mentioned, we can get the commitment order for up to 90 days. This can go for 180 days, and this is easier to keep in effect 180 days, unlike the commitment order that usually does not last 90 days. As you can imagine, this is more suitable for highly functional patients with a good support system. You need real family involvement. You need a patient who understands what's expected of them and has the ability to comply with the order. What are the advantages of using this order? This is the most therapeutic approach. By therapeutic, I mean that it's the best way to help a patient heal. It empowers the patient to take charge of his own health care and be responsible for his own mental health. It gives the patient the structure to know exactly what he needs to do to comply with the order. And as mentioned, it gives something to hang over the patient's head in case he doesn't comply. And if a patient doesn't comply and ends up in the hospital again, the order still stays in effect. There can be stumbles along the road during this 180 days. But just because the patient goes into the hospital for a couple days, it doesn't mean the order is no longer effective. The patient can come out of the hospital and still, be improved after staying in the hospital, and then still have this order hanging over his head to give him the structure he needs. Also, the advantage is sometimes the family doesn't want to testify in court. They feel like they're testifying against the patient. Usually the patient, if they're angry, there are temporary feelings of anger, and when the patient feels better, they actually thank their family for going to bat for them. But this does eliminate those temporary hurt feelings if they occur. But you must have realistic expectations of what the patient can do. And the doctor, the psychiatrist knows what the patient can do. If you enter into an order like this with the wrong patient, it can just be a very frustrating, huge waste of time for everybody. But with the right patient, it can be a wonderful tool. I called someone today to ask them for a status report whose daughter was under one of these orders for outpatient admission. The woman was in tears saying it was wonderful that her daughter had gotten really sick in college, came home, was hospitalized for a while, and then she came to Northwestern, one of the great doctors at Northwestern, entered into an order for admission on an outpatient basis, and was complying, was starting to work part-time. The mom could say enough good things about it. I also know about a patient who had this order who did stumble along the way, but the order did help the patient maintain a more functional life, even though there are occasional stumbles along the way. So this is a very empowering tool. I think I gave you a single piece of paper about involuntary treatment. We'll just lightly touch on this. Involuntary treatment is a medication for mental illness given against a patient's will. It can be drugs or it can be electroconvulsive therapy, which we refer to as ECT. Occasionally it can be both. The doctors are still able to give a patient emergency medicine on a daily basis in the hospital, but this is a standing order for medication every day. When is this treatment sought? This treatment is sought when the doctor feels that the patient could greatly benefit from medication if the patient is refusing medication, either because the patient thinks he's fine, the patient thinks medication is poisonous, the patient is a naturalist and doesn't want to take any medication. There's many reasons. But just refusing the medication is not enough reason. The doctor has to testify that the patient doesn't have the capacity to evaluate the risks and benefits of the medication. So if you have somebody who is very smart and he has the capacity to understand the medication, understand the risks and benefits, and regurgitate those to the court, unfortunately, we wouldn't be successful in a case like this, but most cases, the patient cannot do it. The patient truly lacks capacity. The patient can't see the wonderful benefits that can be had from the medication. What do we have to show to get this type of order? Very similar to commitment. We have to show the patient has a mental illness, that the patient is currently symptomatic and continues to be symptomatic from the time the case was filed. Similar to the 3 crimes for involuntary commitment, there are 3 crimes here that we have to show, or can show one of. One is deterioration. A year ago, Mr. Patient could work, had a family, shopped, cooked, drove a car. Today, he sits in bed and doesn't do anything. And he's sad and he cries all the time. Okay, that's deterioration. Another one is suffering. Suffering alone we can't usually win on because really, suffering, a lot of people suffer. People, even without mental illness, can have a lot of mental anguish. So really the strong criteria are deterioration and threatening. And we've already talked about threatening for involuntary commitment. It's pretty much the same thing. We also have to show the benefits of the treatment outweigh the harm. As you all know, there's a lot of side effects to medicine for mental illness. And some of them are really unpleasant. But medical research has shown that the medicine is the best treatment so far, the most effective treatment for mental illness. So we have to tell the judge, yes, there are side effects, but we're going to do all these tests to monitor to make sure these side effects don't get out of control, that they cause no damage to the patient. So we need certain testing. We also have to show that less restrictive services have been considered and found inappropriate, in much the same way where the judge had to consider whether a nursing home would be better or a group home for the committed patient. In this case, would it be better to do talk therapy? Would it be better to do group therapy? And the doctor has to say, no, I consider those therapies, but really they're not going to work with this patient. This patient needs medication. Lastly, we have to make sure there's no power of attorney for health care or declaration for mental health treatment in existence. So remember, least restrictive, everything else is inappropriate. All the other therapies, cognitive behavior therapy, may be good in of itself, but it alone is not going to solve the problem. And once again, make sure you tell the hospital about the existence of a power of attorney, even if you're not the agent. It'll eliminate sometimes very painful court procedures. Lastly, I'm going to talk about additional tools to get the appropriate mental health treatment for your loved one. And Joe Monahan probably can talk more about some of these, or all of these. First of all, power of attorney for health care, a really strong, really forceful document. This power of attorney lets the patient appoint an agent to make health care decisions for him. And in a broad statutory, form that goes by the statute, this form should be enough to get a patient admitted into a hospital and treated against his will if necessary. However, the patient has to sign it, and that's the kicker. A lot of times people with mental illness are suspicious and paranoid, and they don't want to sign anything. But if you have a patient in a good place and you have a chance to talk to them, you may be successful in getting this document signed. It has no expiration date, which is a wonderful thing, but unfortunately it's very easily revoked. A patient could just say, I don't want you to be my agent anymore, or that power of attorney is no good, I don't want that anymore. It can be a verbal revocation.